number 81.
Hi. Couldn't hear you over the clapping, but I'll assume I can go ahead.
Go ahead.
Okay. My name's Brian Isaac. I'm the chairman of the Canadian Anti-Counterfeiting Network. I'm also a lawyer with the firm of Smart & Bigger, which is an intellectual property boutique. So I make my living enforcing intellectual property, including copyright. The Canadian Anti-Counterfeiting Organization Network is an organization that is directed to fighting IP crime. So we're talking about people who are commercializing stolen intellectual property, including copyright. I've got two basic points that I want to make, and both deal with effective enforcement. But as a starting point, I want to say that we recognize that CACN, and I think everyone in Canada kind of recognizes the need for balance. We need to promote dissemination of information and works over the internet and otherwise. We need to protect privacy because that's a legitimate interest. We need to promote user access and use of works. But we also have to have the ability to enforce. We can't leave enforcement out of the balancing act because you can give all the rights you want, but if you can't enforce them, they're not worth much. So my first point, contrary to what one of the fellows said about no one arguing against notice and for notice and takedown, in our opinion, notice and notice does not give the correct balance. There's too much protection for privacy rights and not enough concern for enforcement. Notice and takedown, in our opinion, gives a better balance. If a person wants to object to a work being taken down, they have to ID themselves, they have to identify themselves, and they can get into the fray with the rights holder if it's appropriate. If they don't object, their privacy is likely protected unless the activity is such that the rights holder is willing to spend the dollars, because rights holders have limited dollars too, to get to court in order to get disclosure of the identity of the person, like that case that we just heard about in New York City, etc. I don't know that DMCA has the correct balance, and we may need some tinkering, and I think Canada can tinker, and we can try and get a correct balance. But in our opinion, the notice and takedown is a better starting point. My second point is that commercial piracy needs to be effectively addressed. People who are stealing copyrights and selling them is a serious issue, and it has to be addressed as a serious issue and a serious crime. Enforcement has to be cost-effective and deterrent. We're currently in a regime where some issues can be easily addressed. For instance, the exclusion of copyright offenses from proceeds of crime legislation should be removed. There's no reason for that. We should also add copyright provisions to the criminal code to overcome some of the jurisdictional issues that we're constantly facing. We could go even further, like some other countries, and put in a ticketing system or something like that to make it more effective, but we have to do something. The bottom line is that Canada needs to get the right balance for Canada. But whatever we do, it's important to change our system from one where pirates view enforcement as a minor cost of doing business. Thank you.
Thank you. Thank you. 500, 138, 22, Webb. There's someone making his way out the door. So let's go to...
So we have a comment from Andrew from Montreal. So the public lending right today delivers $10 million in payments to over 16,000 Canadian authors. The issue statistics of public libraries are analyzed, and the 10 million pie is a portion to each applicant. The amount given out might be very small, but the principle is sound. The UK distributes almost 5 times the amount per author. The same principle can be used to fund authors, musicians, video artists, and so on by analyzing downloads instead of annual issue statistics. Invest in the jewels of our society called public libraries and administer the fund distribution from there. We also have a comment from Omar from Toronto. If the Clinton administration passed legislation recommended in its intellectual property and the National Information Infrastructure White Paper, it would essentially criminalize the vast majority of digital content users. The Canadian public wants assurances that whatever direction copyright laws go, we won't have an approach where citizens are made an example of. Cultural norms have changed, and we should change with it. And... And a final one, perhaps Carolyn from Richmond Hill. Currently, the length of time it takes to obtain permissions for musical or movie works prevents many uses in the classroom environment. What will the government include in the forthcoming legislation to help educational institutions obtain the required permissions to use works legally in the classroom in a timely manner?
Thank you.
Hello, my name is Sasha Isaacs, and I work for AVLA, Copyright Collective. And I have two careers, a daytime career and an evening career. And in my day career, I am a lawyer working in the recording industry representing rights holders. And from that perspective, as someone familiar with various international copyright regimes, I'm only asking the government to bring Canada's copyright laws up to international standards, and that's all. Now, in my evening career, I am a DJ. And like thousands of other Canadian DJs, we rely on specialized digital content in order to run our businesses. In my evening career, then, I'm a content user. And as a user, I want choice. Except in Canada right now, there's not a lot of choice for this segment. There's a couple of different digital specialty services available. And you've compared that situation to the US or parts of Europe, where these new digital companies are thriving, and new ones are popping up all the time. And the simple reason for this is that companies are not willing to invest in a country where their specialized digital content will not be protected by law. So my hope as both a rights holder and a content user is that the government will recognize that outdated copyright laws are actually discouraging legitimate new digital businesses from setting up shop in Canada. And copyright reform that will create an environment to encourage digital businesses and new digital distribution models is needed now. Thank you.
119. Come on down.
Thank you. Hi, my name is Don Hogarth, and I'm from Toronto. I'm a communications consultant with several clients in the entertainment industries. I've seen the negative impact of runaway, unauthorized downloading on my clients. More importantly, I see the impact on people, the people who work at those client businesses. I'm talking about the staff who come to work and face a layoff notice. And I'm talking about the artists, the performers who can't earn a living. Many of them can't even get a start, as we've heard from the folks at Warner who spoke already. I'm also worried about the impact on Canadian culture. When sales are lost to downloading, money that would otherwise be recycled back into the system that would support artists, that would support Canadian music or movies or TV or all the cultural goods that we enjoy and I think take great pride in, that money is not recycled, it's lost. And for too many of the creators of tomorrow's Canadian culture, they're stopped cold in their tracks. Reform opponents often frame the debate as one of between big business and people. But if you look at the cultural industries in this country, yes, there are some big businesses, but most of them, in fact, are Canadian-owned, 100% Canadian-owned, are small business, in many cases very struggling businesses. And behind them all are the people who work in them, of whatever size of business they're in, and those people, in turn, support the artists and the creators, but that work runs into a wall of unauthorized downloading through an outdated copyright regime. The legal uncertainty that currently exists in this country leads too many Canadians to believe that it's okay to go to file sharing sites to get anything they can acquire digitally, or in other words, to call a spade, to take other people's property without their permission, so long as it's over the internet. So Canada must modernize its copyright regime immediately to send a clear signal to Canadians about what is acceptable and what is not on the internet. Minister Clement, please step beyond the rhetoric, step beyond the myths, and there are many myths out there right now that are floated by opponents of modernizing Canada's copyright regime. We hear about a police state, we hear about locking down creativity and culture, teachers who can't teach, and all of our major trading partners that have implemented the WIPO treaties have not found that to be the case. They have, the regimes are very successful, they're copyright regimes. So ignore, the evidence doesn't stack up for all these myths, so I urge you to ignore the myths. The principles outlined by the government on introducing Bill C-61 capture the essence of the reforms we do need. So please, let's inscribe those principles into law now. Let's inscribe them under the guidance of the WIPO treaties, a framework that has proven to work successfully among all of our trading partners. Thank you.
Thank you. I know this